Hello everyone, it's Harry Sherrard here and welcome to video 9 of my Employment Law Foundation course. So in this video we're going to be looking at a situation where there's a disciplinary or a performance review raised in respect of an employee, and that employee then responds to that by raising a grievance. Now many employers still seem to believe that in that situation you have to pause the disciplinary or the performance review, deal with the grievance first, and then go back and resume the disciplinary. Now that might be the right way round of dealing with things, but that's actually the exception rather than the rule. Generally speaking, you will actually run the two processes together. Now why do I say that? Well, the magic number is 46. Paragraph 46 of the ACAS Code of Practice on Disciplinary and Grievance Procedures. Very useful bit of information in there. I recommend you go on the ACAS website. Read the whole Code of Practice, of course, but for this purpose, particularly paragraph 46. And what it says is that if the subject matter of the grievance overlaps with the disciplinary or the performance review, then the subject matter can be dealt with concurrently. So, for example, and this is quite a common example, let's say there's a performance review initiated by the employer. The employee responds by raising a grievance saying, my manager doesn't like me, he has bullied me, he has given me hard and difficult work, that's why my performance has been low. Those matters clearly overlap, that is all one conversation. So the employer can say, that's fine, you've raised a grievance, we're applying paragraph 46 of the ACAS Code of Practice and we will deal with matters concurrently. So there is one meeting and there is one outcome. And you do take into account what the employee says in terms of the grievance, but you don't need to have a separate activity in relation to the grievance. So what the outcome letter might say, for example, is I am issuing you with an improvement note because your performance hasn't been to the required level. Next paragraph, it therefore follows that I do not uphold your grievance that your manager has given you inappropriate or difficult work to do. So that's what we mean by concurrently. You're dealing both with the performance review and the grievance in one process and one letter and one outcome. It's not necessarily legally wrong to separate things and have a separate grievance stream, but it always seems to me it's a terrible waste of employers' resources to have two processes running rather than just one. So I hope you found that helpful. Before I go, I just want to tell you about our webinar coming up next week. As I speak to you on Tuesday, the 5th of May, the event at 4 p.m. Monday, the 11th of May is almost full, but there may be a couple of other places there. Managing redundancy in the pandemic. If it does fill up, then we will run it again the week following, but Sarah's details will be appearing on screen shortly. So if you do want to know more information about that, please send Sarah an email or alternatively go to our website at sherrardslaw.com and book your place there. Thank you very much, and I look forward to speaking with you on video 10 shortly.